Back with us on the SportsMax Zone. The High Court in Trinidad and Tobago has ruled that FIFA's installation of a normalization committee to administer football in the country is illegal and therefore null and void. The judge who heard the matter, Justice Carol Gobin, declared that the removal of the elected TTFA executives by FIFA on March 17 this year was an illegal move. Justice Gobin also ruled that FIFA's installation of the normalization committee was made in bad faith. Here are the highlights of her 57.23-page ruling. Point 36, a very important point, talking about the vesting of the power and responsibility of the TTFA Act for the management of the TTFA in the Executive Board of Directors. That's where the power lies, and its prescription of how the TTFA is to be elected, how elections are to be conducted. She says normalization effectively permits the removal of a body elected in accordance with the law and the transfer of powers vested under statute to a committee through a process which is outside of the election process established by the law. She says this is illegal. Then she quotes case law. Well, in this case, yes, she does so. And she says, if the thing stipulated for, if that which is stipulated for is itself contrary to law, the paction by which the executions of the illegal act is stipulated must be held to be intrinsically null. Yeah, even if you're not a lawyer or a legal scholar, you would understand this. I think this is clear. A very good choice of reference here by the judge, and she says she considers this principle applicable. Then, even assuming that FIFA's normalization statute was valid under TT law, and it is not, for emphasis in brackets, it is only activated in exceptional circumstances. She says there's no definition of what amounts to exceptional circumstances by FIFA, and that the rule of a normalization imposition essentially gives FIFA a free hand. She says, however, the absence of that definition does not limit my ability, her ability, the judge's ability to consider the circumstances of it and to determine the lawfulness of FIFA's actions. She says she's considered the evidence and she has concluded that the decision to invoke normalization was unwarranted, uncalled for, unwarranted, and indefensible. She says, 46.46, even as it finally imposed the threatened sanction of banning TTFA, FIFA was clear and unequivocal in its refusal to accept the jurisdiction of the TNT court. Yeah, she says FIFA disclosed that in its view, the decision to go to a TNT court jeopardizes the overall global football governance structure, and making it clear that TTFA was suffering the consequences of a decision to access the TTFA. So the TTFA punished for going to a local court. She says, if this policy of FIFA's is to be effective, then it can only mean the FIFA does not recognize the courts and the judicial system in any of its 212 member states. And she says, in her view, this is an astonishing position for any entity, however powerful, to adopt, especially one that has control over a world institution such as football, or for that matter, any other sport. She says, as for its insistence on submission to CAS in accordance with its own rules, FIFA assumes, she says, wrongly, that Statute 59, speaking to where members can go for justice, that effectively blocks all access by its members to courts in their sovereign states. She says agreements to submit to arbitration or designated tribunals are not uncommon in the sporting world and in other areas. By such agreement, parties do not deny the jurisdiction of the courts and the rule of law. Rather, they agree that the courts would generally hold the parties to the agreement and the courts generally decline jurisdiction. This is a very, very crucial point which I'm going to ask eminent counsel to expand on. But she says there are some cases in which the court will not hold the parties to their agreement, and she has already decided that this is not one of them. If it is the case, as FIFA continues to insist that it will not accept the jurisdiction of the TNT court or the court of any member country, and that the Court of Arbitration for Sport is the only dispute resolution forum that it will recognize, given what the evidence has disclosed and which it has not denied, that FIFA generally does not comply with a basic rule regarding the payment of its shares of the cost of arbitration, even when its non-compliance can have the effect of denying parties access to arbitration process, as it did in this case. She says there is every danger FIFA will become a law unto itself if it hasn't already become one. 49. The suspension notice ended with a further demand for TTFA to bring its rules in line with the FIFA statutes. FIFA is surely aware, Justice Gobin says, of the extent to which the TTFA rules already comply with FIFA's own rules. It has all times had to approve them. In every material respect and insofar as they are applicable, TTFA has enacted rules which mirror FIFA statutes. So she says TTFA has been in accordance with what FIFA has set down. She says there is no lacuna, there is no gap. The futility of the threats by FIFA and demands should by now have become obvious. TTFA simply cannot deliver what FIFA has asked it to do in terms of abiding by its rules. The only amendment that can produce the result FIFA commands is an amendment to the TTFA Act, and if it insists, meaning if FIFA insists on blocking access to TT courts in favor of the CAS, then it should be put on notice there might be constitutional hurdles. 50. These findings, she says, are enough to dispose of this case, but I am constrained to make some further remarks. Throughout these proceedings, FIFA has persistently paraded its disdain for the authority of our local courts, thumbing their collective nose at the local courts, Justice Gobin says. In doing so, it has demonstrated a disregard for the rule of law in TNT. The defendant's conduct, FIFA's conduct, regrettably calls into question the sincerity of its vaunted commitment to achieving its objectives to promote integrity. And here she's quoting what FIFA's, you could call it their mission statement then, is saying: fair play, friendly relations in society for humanitarian objectives. She says disregard for the rule of law is inconsistent with FIFA's stated objectives. 51, more egregiously, throughout, it sustained an unrelenting campaign against the TTFA. FIFA did, according to Justice Gobin, the overt aim of which was to force it, a litigant before the courts of this country, to withdraw its case. Its threats, she says, were pointed. She says the defendant, TTFA, well, FIFA, TTFA of course a claimant, the defendant conducted its campaign while it remained ensconced in its home in Zurich. So it insulated itself from the fray in Zurich, and as a result, it will probably manage to escape the consequences of its unlawful behavior. Were it otherwise, FIFA may well have attracted the exercise of coercive powers of the court. 53. The claimant has asked me, the TTFA has asked me, Justice Gobin says, to find that these interventions were orchestrated by agents of the defendant to undermine the proceedings. But, she says, I am not prepared to ascribe improper motives to the Honorable Minister, Shamfa Kodjer, for her intervention to find a way forward, nor indeed to the delegates who requested an emergency general meeting. She says, these were concerned parties who would not have been aware of the negative legal implications of their actions, which I do believe were well-intentioned. However, here's this part now. She says, the same cannot be said for Robert Haddad. On the evidence, I am, however, left in no doubt that Robert Haddad, as FIFA's appointee and head of the Normalization Committee, was actively encouraging the campaign of pressure on the TTFA, and that this gentleman, Haddad's conduct, is harder to ignore. She says, I find that in his role as chairman of the Normalization Committee, Haddad deliberately engaged in conduct that was calculated to subvert the adjudication of the claimant's claim by the TNT High Court. She says Robert Haddad's actions prompted the TTFA to seek injunctive relief. FIFA did not resist the application. All right, key shot now, 57. She says simply, there shall be judgment for the TTFA. The court declares that the removal of the executive by the defendant, by FIFA, is illegal, null and void, and of no effect. High Court in TNT declares that the appointment of a normalization committee to, look at the word she chooses, interfere in the affairs of the TTFA is null and void and of no effect. The TT High Court declares that the FIFA Statute 8, Section 2, Subsection 2 is inconsistent with the provisions of the TTFA Act number 17 of 1982, the statute which gave life to the TTFA she's citing there. Then Part 4, the High Court declares that the decision of FIFA to appoint a normalization committee was made in bad faith and for an improper and illegal motive, and that FIFA will pay the TTFA's costs of the action to be assessed by this court. And she signs it, Carol Gobin, judge. She is one of 35 judges of the Supreme Court in Trinidad and Tobago. Well, joining us on Zoom now is the attorney for the TTFA, Dr. Emir Crowne. Dr. Crowne, welcome to the SportsMax Zone, sir.
Yeah, thank you for having me.
Good. The first place to start is this. Where the matter concerns the law of contract, is the law of contract with FIFA Trinidad law or Swiss law?
So when you say the law of contract in relation to what?
No, because in the judgment, Justice Gobin said early that this is a contractual matter, and she made several points about that, talking about the fact that the TTFA was established by statute, public entity, and that there can't be a private agreement between, well, a public entity can't be involved in a private agreement, talking about the contractual nature. In fact, let me raise the point in the ruling where she said, just to be precise, she spoke to the point 11, the nature of the relationship between FIFA and the TTFA is contractual. So it's on that basis I asked the question. Is this talking about Trinidad law or Swiss law? I think it's important to just start the discussion there.
Right. Well, I mean, she said it's contractual in the sense that the TTFA has at least signed up to FIFA statutes. So as part of TTFA's governance structure, the FIFA statutes are incorporated there by virtue of agreement. And those statutes they themselves would claim to be governed by Swiss law.
So it's Swiss law. Okay.
Well, no. I'm being very clear because you asked if the matter was governed by
the contractual aspect of the matter.
Law.
Yeah.
But the TTFA is an act of Trinidad's parliament.
Yes.
And the laws that would apply to it would ordinarily be Trinidad and Tobago's laws, but by virtue of FIFA's membership, they have signed up to statutes that the statutes themselves would claim that their interpretation is governed by Swiss law.
Excellent. Thank you for that. Section 3A of the TTFA Act, number 17, 1982, it says that the aims and objectives of the TTFA, called the association in the legislation, is to regulate and control the conduct of football in Trinidad and Tobago under FIFA's system. If it's under FIFA's system, why did the judge give little or no consideration, in my view, to this in her assessment of the evidence brought before her for her to make her judgment?
Well, I mean, I can't say what the judge was thinking or not thinking, quite frankly. But what was raised before her is Section 4 of that act, which expressly sets out how the executive is to be appointed, at least as far as the Parliament of Trinidad and Tobago is concerned. So it's one thing that the act speaks of the regulation of football under the FIFA system, but the act goes further to prescribe certain powers and so on that remain in Trinidad and Tobago then, that remain within the domestic territory of Trinidad and Tobago. So it's not a complete surrender to whatever the FIFA's statutes may say or not say.
All right. Is the judge saying, and of course being party to it, you are very well placed to answer this question, is the judge saying that the TTFA's agreement to submit to normalization was a private agreement? I wasn't clear on that in reading through the 23 pages of counsel. Could you help us?
Well, again, it's not, there was no agreement at all. So that's what the decision is about, that the fact that normalization itself was forced upon the TTFA. And that, even though the FIFA statutes prescribe that ability of FIFA, the TTFA Act in Trinidad prescribes or speaks to the election of executives. And so that's the fundamental disconnect, that by virtue of contract, one signs up to the FIFA statutes, which prescribes a normalization power, however vague that may be, but the Trinidad and Tobago Football Association Incorporation Act, that act prescribes how the executive is to be elected. So between FIFA statutes and an act of parliament, the High Court, as any domestic court would, gave primacy to an act of parliament.
But the TTFA have been a part of FIFA since 1964, and since that time, the TTFA have had a president and an executive. And the fact of Article 59 of the FIFA statutes and the fact that it doesn't marry with the FIFA statutes was never raised before, Dr. Crowne. So in this case, FIFA would have accepted that clearly it can't subject itself to the laws of each of its 212 members, which is why it sets out the statutes in the way it does to say, well, look, we can't settle these things in a local court unless we give leave for you, we give permission for you to do so. It is the CAS that we should go to. So it's almost as if FIFA, wanting to get away from having to deal with 212 courts, sets up a court. So I'm saying, from that perspective, didn't the TTFA accept the terms of normalization, accept the terms of Article 59 when it became a part of FIFA in 1964? And how can you then challenge that aspect of the agreement that you signed with FIFA now?
Well, I mean, as a first point, I mean, the CAS didn't exist in the 60s or the 70s.
No, it didn't, yes.
But what I will say is the mere fact that someone hasn't challenged something doesn't mean you've acquiesced to it. I mean, there are many laws on the books that remain unchallenged for years. And the mere fact that no one has challenged it doesn't necessarily mean that, well, we had no problem with it all along, so therefore, how can we challenge it now? I mean, if that argument flew, then most defenses in criminal law and law generally would fly out the window.
But the normalization committee, based on what FIFA has done, first of all, TNT is not the first place for a normalization committee to be installed. It has happened several times before. And the normalization committee was not installed as punishment of this executive. It was installed to right the ship off the TTFA. 50 years from now, I'm sure there'll be a TTFA. For 56 years ago, there was a TTFA. So if it is that the normalization committee was illegal, how is it that FIFA and its statutes had agreement from the TTFA about the arrangement, and the TTFA is now picking that aspect to say, oh, well, this aspect of the agreement we signed with you is wrong, therefore you can't impose a normalization committee to straighten out the affairs of the TTFA? I'm not clear on that.
Well, I mean, you're asking the question in a loaded way, quite frankly. I mean, the issue is FIFA has required member federations to adopt wholesale its statutes, what it laudably calls statutes. And no federation can cherry pick and say, well, we object to, statutes 12, 13, 14, and so on. So it's not a matter of saying, well, why didn't X, Y, and Z federation that's been normalized, including the TTFA, why haven't they objected to these clauses before? That, in my view, is not a fair assessment of it, because nobody can get to pick or object to FIFA statute. Either you accept it or don't. And so to suggest that, well, why didn't they raise a stink before in a vacuum? That question, it begs more questions. Could you imagine if the TTFA said, oh, we object to 8.2 of the statutes? Everybody would laugh at them, including SportsMax. You all would run segment after segment of saying, why are these people raising a stink in a vacuum? What's the likelihood of normalization? So quite frankly, I think you're asking a question that begs further questions.
Point 44, and I know you know this document well, so I can highlight it. Point 44, talking about the normalization notice issued by the FIFA General Secretary Fatma Samura, and it says, Justice Gobin says, on the evidence, I find that the decision to activate the normalization was improper and made in bad faith. The conclusion that it was a contrivance to subvert the outcome of the November 24 elections is, in my view, inescapable. In the end, it defeated the will of the persons who had elected the new board into office. In the circumstances, FIFA's claim that it remains neutral in matters of politics within the sport is demonstrated to be patently false. Is the judge saying, counsel, that the imposition of normalization was payback for David John Williams losing the election, or payback for William Wallace winning the election?
Well, I mean, there are two sides of the same coin. I mean, the record will show that days before the elections, Infantino himself came to Trinidad and Tobago and is quoted as praising David John Williams and his management of the TTFA.
I was there. I heard him.
And so if we were to extrapolate, and I'm very careful what I'm extrapolating from the decision, but it's clear that Justice Gobin, she viewed normalization as effectively FIFA stepping in when an election perhaps didn't go the way that the powers that be may have wanted them to go. And she calls it, in her view, it is, in my view, inescapable. And quite frankly, I think that is what the public narrative has always been. It's been an executive that came in on the platform of transparency and so on, and won the election, perhaps to the surprise of many, including those in Zurich. And then normalization occurred shortly after that.
Dr. Crowne, hold it right there. We're going to take a break and we come right back and pick up this discussion. We're talking to Dr. Emir Crowne, attorney for the United TTFA. They have won their court battle with FIFA at the TNT High Court, and we're talking to him about aspects of the ruling handed down by Justice Carol Gobin. More after these.
Welcome back to the SportsMax Zone. We continue to discuss the ruling of the High Court Judge Carol Gobin in Trinidad and Tobago. On Tuesday, she declared that FIFA's installation of a normalization committee to run the affairs of football in the country was illegal and therefore null and void. Justice Gobin also ruled that the ousting of the elected TTFA executives, including President William Wallace, was also illegal. Reacting to the judge's ruling, Trinidad and Tobago Prime Minister Dr. Keith Rowley posted this statement on Facebook. Another such victory and we shall be utterly ruined. Pyrrhus, king of Epirus, 2,000 years ago. Thank God I was taught some Greek history and Latin at Bishop High School. Otherwise, I would have never been able to understand that adventure. I think we all now need to study the 2,000-year events of the Pyrrhic Wars to figure out how it all might end. Pyrrhus was indeed king of the Malaysians and also of Epirus. However, Rome still stands, so what does the future hold? Success that comes at such a high price and at other people's expense sometimes results in the price of the victory, proving too costly to have been worth it. In that case, what happens when the powerful king wins the battle, but the thousands of subjects lose? So now, United TTFA has won and FIFA has lost. The matter is settled in local court. We are now free of the colonial FIFA. We boys and girls, men and women, are free to play by ourselves and against ourselves because nobody will be allowed to play with or against us. Oh, that's it. I finally understand it. That means we can never lose and we will always win because we will only be playing by ourselves. Brilliant. Well, the attorney for the TTFA, Dr. Emir Crowne, responded to the Prime Minister's post. A sitting Prime Minister berating a High Court decision within hours of its release would be an absolute scandal in any other country except the Republic of Oh God Gidem. Hashtag separation of powers, hashtag Trinidad, hashtag politics, hashtag island life. Well, Dr. Crowne is still with us, and my question is, why such a rebuke for the Prime Minister, Emir?
Well, thanks for posting my Twitter, my tweet there. So, I mean, the rebuke is exactly as you read it. So I'm not sure what more needs to be said, except that it is an ongoing court matter, and you have a sitting Prime Minister who is effectively commenting and berating a High Court judge. And in any civilized country, that would have attracted a lot more criticism and attention. But Trinidad being Trinidad, it's just seen as as a more bacchanal and you know, the usual, oh good, look, we Prime Minister showing them up.
But Dr. Crowne, in the recent Brexit wars, the previous version of it, late in 2019, the British Prime Minister Boris Johnson did criticize Lady Hale, the President of the Supreme Court in Britain, after she ruled that his prorogation of Parliament was illegal. While he was in New York, he was interviewed and he did criticize the ruling, even though he said that I'd abide by it. And then the Attorney General, Geoffrey Cox, went into the House of Commons and gave Lady Hale's ruling both barrels, and the Speaker of the House, Jacob Rees-Mogg, also did the same. And apart from those who were against Brexit, no one, that didn't trigger a opprobrium in the public domain against the Prime Minister, against Geoffrey Cox, or indeed against Jacob Rees-Mogg.
Right. Well, again, I mean, with all due respect to SportsMax, you're being quite equivocal and sensational, which is fine.
No, I was just pointing out. I was just pointing out, Dr. Crowne.
To respond,
but I was just pointing out.
If you're going to air
yes.
my personal tweets, you would allow me the courtesy to respond.
No, what I'm saying you.
If you would allow me to respond.
What I'm saying, sir.
What you're saying
yes.
is that comments were made in the House of Commons.
Yes, and in New York at a public forum.
That is where comments are permitted
no,
to be
sir.
made.
I said, which is why I'm keen to straighten out what I said. I told you two things.
I am keen.
I told you two things. I told you two
Lady
things.
Hale, the decision of Lady Hale
yes.
was one made by the Supreme Court.
Yes.
It was a final decision.
Yes.
And therefore, one can make comments about the final decision.
Yes.
There is still an appeal window. There is still. Why are you shaking your head then? I would like to know.
No. I'm shaking my head because the matter wasn't appealed. It went to the Commons for another vote, which effectively made that ruling null and void. And I just pointed out two things to you. I pointed out Geoffrey Cox in the House of Commons. I pointed out Jacob Rees-Mogg in the House of Commons. But I was keen to tell you up front that Boris Johnson's response came outside Parliament. He was at a function in New York. And I said to you, all I was doing, you said that in Trinidad and Tobago, this goes without criticism, but to say in any self-respecting democracy, it would have attracted criticism. And I was just pointing out to you that, one of the countries, one of the OECD countries who people always point to, it has happened there, and the sky has not caved in on Boris Johnson's head, was the point I was making.
Right. Well, perhaps, again, if you would allow people to finish, as opposed to sensationalizing issues like SportsMax tends to do.
There was no sensationalizing.
No.
There was putting in context.
Listen, I mean, honestly, can we be clear? Lady Hale, the decision was made by a final court. And once it's rendered by a final court, then public criticism and commentary is fine. If it is still subject to an appeal, or if there is still an appeal to be heard on Monday on the procedural point, it is irregular for a sitting prime minister. The comment. You expressly said Lady Hale.
Yes, sir.
And the decision of Lady Hale would have been one given by the Supreme Court.
Yes.
So if you are going to paint an equivocal picture, at least draw an appropriate analogy.
No. And the analogy is quite opposite. It's more than appropriate.
No, just because you say so, it doesn't make it
it's not a matter of me saying so. It's a matter of record. It's a matter of public record.
The matter is still before the local court.
Dr. Crowne.
There is an appeal window that is still live.
Dr. Crowne, just admit you were caught on the point. You said that there was no criticism of Dr. Rowley for saying what he said. And I pointed out to you something that was said by a prime minister criticizing a court ruling. And I said the Brexiteers who funded the court challenge themselves, they were the ones who said, oh, how is it that the Prime Minister is criticizing a decision like this when it is, you said it, and I accept what you said, that it is irregular for that to be criticized. But I'm saying that Johnson did criticize it, and there wasn't the public criticism of a kind that you're saying is not attending to the situation with Dr. Rowley. That's all I was saying.
And what I'm trying to say is I'm trying to correct the clear equivocation you're trying to make. The comments made in England were made after the Supreme Court, the final court of appeal, had ruled. Here is a decision released, and mere 3 hours, 4 hours later, a sitting prime minister is berating it. And I understand you're shaking your head because I'm pointing out the fundamental error.
No, there's no error there. You have gone to the inner sanctum of the point to raise an error, but there is no error.
But again, if you intend to speak over people and make comments and always get the last word, then fine.
No, that's not true. You are my guest and I'm treating you with respect because you're a man who deserves to be treated with respect. All I'm saying, I pointed out a parallel example to you and I don't know why you would have thought about that.
The example is flawed.
No, the example cannot be flawed, Dr. Crowne. The example cannot be flawed. Those who follow...
FIFA can still appeal the decision.
Yes.
The decision of Lady Hale could not have been appealed.
And I'm saying that's not the context you were saying it in. The context you were saying it in was the authority, the office that the ruling came from. Usually, for prime ministers to speak out against decisions made by a powerful office such as a court, usually that would attract a problem, and you're saying the absence of that in TNT, you said hashtag Island Life, and I'm saying, well, in the UK, something has happened, and Boris Johnson, apart from the Brexiteers, Gina Miller and company, and those on the Labour benches who wanted to see Brexit not happen, there was no problem around the Prime Minister's comments. That's all I was saying.
Well, I mean, you have characterized it as being no problem because it suits your interest.
Not because it suits my interests. It's a matter of record, Dr. Crowne. It's a matter of record, Dr. Crowne.
It does not mean that is the case.
Those who know the Brexit situation very well know what I'm saying.
While I appreciate SportsMax taking one of my tweets and reading it back to me, if this is how you intend to conduct interviews in the future, then please do not contact.
No, sir, you are our guest. We have very good relations. We have very good relations with you.
You invited me on your program. If you intend to read out my tweet
but why?
For sensational purposes.
But why are you poisoning the well? Because
I'm making this very clear.
No, and we are making it clear that we invite you, and when you say things and we challenge them, you should accept that we have a right to challenge what you said, especially.
And I am responding to them.
Yes.
But you are not allowing my response.
I'm allowing you. Of course, you will give the space to speak.
You are indicating that the analogy you have given is
correct.
Flawless and is a perfect analogy. And I'm telling you,
I didn't say it's flawless or perfect. I said it was opposite.
So we have a difference of opinion on that.
Right.
Merely because you say so, it doesn't mean it's right.
Right.
We have a difference of opinion on the matter.
Yes.
And we can leave it there.
But
you insist on pressing the matter.
No, I'm not insisting.
What you are doing is you're trying to draw the situation down a rabbit hole.
No,
and not focus on
that's what you
So
attempt.
that is fine if that is what is necessary for viewers and so on. I understand. I appreciate that.
No, sir. You see?
If the intent is to discuss the ruling, I'm more than happy to do that.
Yes, but I'm saying, sir, you said that the program that I am a part of, that I am in charge of, you said that it's prone to sensationalism. I have a right of defense. And in the same way that you say, if this is how we're going to conduct interviews with you, we should not call you. If this is how you're going to conduct yourself when you come here, we will not call you, sir. But we have respect for you. We have respect for you, and we're trying to discuss the ruling here. That's what we're trying to do. Yes. So we're trying to discuss it with you. Can we continue? Can we continue talking about the ruling?
If that is what you would actually like to get back
to,
yes.
For sure. Let's go. Lance?
All right. Dr. Crowne, you mentioned earlier on that in the same Rowley Facebook comment that from your standpoint, based on what I'm gathering, is that you shrugged it off as, typical Trini, taking things lightly and the bacchanal and so on. But could it be that the vast majority of the people in TNT actually agree with the Prime Minister's comments, which is why it didn't cause the backlash?
I haven't conducted a poll. I can't tell you what the vast majority thinks.
But we based on our interaction with TNT and the Post and everyone we have interviewed, it seems that it's a big minority that had been standing by the United TTFA on this legal matter.
I can't speak to that. I haven't seen any polls. I haven't conducted any myself.
Yeah. All right. You said something earlier on as well that the position that the United TTFA had taken when they were resisting the normalization committee and even the High Court judge's ruling accepted. You mentioned this earlier on. Accepted that initially a vast majority of the people involved were slighted by FIFA's apparent high-handed position that they had taken. But in many interviews that we have done, it seems apparent that even though they recognized in their opinion that FIFA had been high-handed, it was futile for the TTFA to continue a fight that they could not win. Now, this ruling is a domestic success for TNT, but on the global front, TNT remains outside of football, and the immediate future looks pretty dark for TNT, doesn't it?
Well, there is an ongoing CAS appeal to deal with the suspension. So that matter is still before the CAS.
Yeah. How good do you think the United TTFA's chances would be at CAS?
I'll tweet about it and you all can read it.
How soon will that tweet come?
Well, you tell me. You tell me.
No, but I don't do your tweets, Dr. Crowne. I don't do your tweets, so we'd be anxiously looking for it.
You know, when you'll just stand by, and when I tweet, you can read it out.
All right, but I started off the show by suggesting, and of course we don't have the statistical evidence to support it, but it seems in TNT that most people are disappointed with this continued fight by the United TTFA, battling a situation that is without question hurting TNT's football at the moment. Is that something that is that a view that you entertain or embrace in any way?
Well, we're not tone deaf to the implications or the implication that have arisen from the dispute, if that's the question.
Finally, Dr. Crowne, in point 55, Justice Gobin says, the wisdom of the challenge by TTFA of FIFA's actions is not for the court. And this rides on a question Lance asked. From the perspective of the members of the TTFA who have sought to hold meetings with William Wallace and his team, and even from Robert Haddad's perspective at the helm of the Normalization Committee, wasn't that the issue all along? People saying, well, you know, is it wise to do this? Because we have won here in court, but we remain banned. We can't play any football. We can't organize as we used to. And nobody knows what the future holds.
Well, as I said, that there is an ongoing appeal at the CAS to deal with the suspension aspect of the dispute.
Well, I'm just asking you just the same. What effect do you think the absence of FIFA from the proceedings, robustly defending its position, what effect did you think that have on the ruling of Justice Gobin?
I can't say what was or wasn't in the judge's mind when she was ruling.
Excellent. Thank you for your time, Dr. Crowne. All the best. Dr. Emir Crowne, attorney for the TTFA in the matter concerning its battle with FIFA. You know, this is, Mr. Director, I'd like to see my colleagues, please, when I speak there. Yes. So here's the thing. We have a serious situation on our hands. I have the utmost respect for Justice Carol Gobin.
Yeah.
She says that, look, based on the law, this is what she's ruled, and fine. There are several aspects that I have questions about. I wish I could put these questions to the eminent justice, but I can't. And we had a good conversation going with Dr. Crowne until he sought to besmirch the reputation of the show. And we would be fools to sit here to let someone say we are sensationalizing stuff when we aren't. And we had to defend against that. But that's the tangential issue. The broad issue here is this. The country's Prime Minister has said that TNT-FA have won a Pyrrhic victory because they've won. William Wallace is the president of the TTFA. But what is he the president of, if you understand the question? That I'm asking both of you. He's the president of the TTFA. But given that the TTFA is banned, what is he the president of?
Well, there's nothing because, there's no football that's going to happen. There's no money to pay the coaches that have been asking to be paid. There are so many things that need to be done. And the Prime Minister said it itself. We'll have to play among ourselves and win. Lance?
Well, several weeks ago, I used the exact word about the Pyrrhic victory and mentioned at the top of one of our shows.
After Andy Roberts' discussion with
about
us.
2.5 weeks ago when we spoke with him, that, you know, in pretty much the same way that the Prime Minister mentioned, you go to battle in a war, you are the leader of your troop, and you defeat the opponents, but all of your soldiers are dead, so there's no celebration there. Now, I want to continue to make the point before we wrap this segment that I accept, based on my experience in the sport journalism, that FIFA is a body that sometimes irks people, and their power and the way they are quite often not very transparent.
Yes.
We have to
How
say
they do
that.
things.
Absolutely right, you are.
And they are above the law in any particular
And the
country.
manner they do things.
Yes. So I know that there are people who will quietly back any fight against what FIFA represents.
Correct.
The fact, though, is in this particular case, Trinidad and Tobago by itself trying to fight this battle appears to be more hurting than helping. And I'm not sure it's a battle they can win in any way, shape, or form. On that same show I had mentioned, I'm not sure if 50, 60 years down the road something could happen to this FIFA empire and people will look back on this Trinidad and Tobago fight and say, you know what, they had a point there. But it just appears at the moment that there's going to be too much suffering, too much death as far as football is concerned in Trinidad and Tobago to make this victory worthwhile. So that is my concern.
Well, only time will tell, because you're quoting things 50 years, and we'll see if Trinidad and Tobago will be the one to make the difference. We'll wait and see.